Guess who back in the building, family, with another video. Part 3 to the video, right? And I'm breaking this down for y'all so y'all can understand how this works. Okay? So, let's talk about this again. And I told you I'm going to start off where I left off on the last video with the palms. We'll talk about trust. Left that particular point, but I want you to understand this information as I drop it on your head, aka Young Johnny in the building, aka Bushead Fred, and understanding this stuff, man, and how you need. I told you this is a critical thinking exercise, family. So let me stop the song real quick and let's get into this as we talk about the source and we start talking about property. So we're going to say a private charge. We're going to talk about a charge, a private charge on property. A charge is where immovable property of one person is made security for payment of money to another. Okay, it's immovable property. So what I mean by immovable, it's attached to your person and it cannot be removed. Even though it's personal property and it can move, but it's attached to your person. So that's why a lot of people talk about the name, the copyright, but they don't know what they're doing in essence of this contract stuff. It says it refers to a security for securing the debt by way of pledge to hypothecation and mortgage. No personal liability is created in the charge, but when it comes into effect due to a contract, then personal liability can be created. So what they saying, initially it's not created until the person put the obligation in the contract. When we talking about mortgages and stuff like that. So you were giving them the securities, and you got to understand what you did when giving them the securities. Okay, so what that did, there was a trust relationship. Then they turned around and tricked you into, they loaned you some monies in regards, right, under a money of exchange or money of accounts where there really is no money. So you got to understand really what's going on in relationship to these factors so that you can know how to create your contracts. Because I told y'all this is a critical thinking exercise. No more, no less. Y'all need to understand this. So let's go to, I talked about original, and we're going to go to the source. We're going to talk about source of law. A lot of y'all ain't never heard this. I keep talking about, there go that word origin, coming from original. Okay? Something such, it says something, and then in parentheses, such as a constitution, what? Treaty, what? Statute, or custom. So when we talk about customary law, and we understand we're talking about contract law, how to invoke your customary law into your contract to give it original jurisdiction over the property and the rights associated. I told you the law follow the property. That provides authority for legislation and for judicial decisions. So you got to understand when we're talking about this property rights, that how this stuff supposed to work and who supposed to hold this and enforce and protect the rights. This is why you got to have a trust protector that can come in and protect the rights of the beneficiaries in a hearing. Right? A point of origin for law or legal analysis. Also termed fons juris. The term source of law is ordinarily used in much narrow sense that will be attributed to adhere. In the literature of jurisprudence, the problem of sources relating to the question, where does the judge obtain their rules by which they decide a case? In this sense, among the sources of law will be commonly listed statutes, judicial precedents, and customs. The opinion of the expert, morality and equity. So you can go through, pause it, look at the video. Let me see if I can blow it up. You can pause it and then just read it, right? Just read it. I'm going to try to see if I can make it a little smaller. Just read it, family. Just read this, right? So that you can understand when we talk about source of law, original jurisdiction, dealing with original parties, with original property, and all the claims associated with understanding how to move. I'm trying to tell you how to critically think about contracts just to let you know this stuff. Now, let me blow this up, and because I want to go over this before I start back at this, before we go back to here. Right, before we go here, I just want to come here first. I want y'all to understand when we talk about pleadings, right? Pleadings, special pleadings, the common law system of pleadings that requires the parties to exchange a series of court papers, such as replication, rebutters, and surrebutters, setting out their contentions in accordance with the hyper-technical rules before a case could be tried. Often, therefore, cases were decided on point of pleading and not on the merits. This is why I always talk about due process. I never was arguing the merits. We was decided on the pleadings. We were looking at the pleadings. So what are you going to do? We talking about contracts. Contracts. Special pleas, special pleadings. Special owner. The art of drafting pleadings under this system. That's the second sense. In an instance of drafting such a pleading, that's number 4, a responsive pleading that does more than merely deny allegations, as by introducing new matters to justify an otherwise blameworthy act. So, I was talking to my brother the other day, talking today about some stuff, and we breaking this stuff down. This is why I say y'all got to know how to plead. When I did mine, I did my answer to the complaint with support of the complaint, affidavit in support of the complaint, and then with exhibits. Come on, family, let's go. An argument that is unfairly slanted towards the speaker points of view because it omits unfavorable facts or authorities and develops only favorable ones. Do y'all understand? I told you I litigated for so long. Y'all not gonna get this game reading no damn books or listening to some guru who ain't got over a decade in litigation. A lot of people gonna tell you these procedural requirements, but they don't know how to effectively enforce what they understand, because they want to talk to you about some damn procedure, and the issue of it is y'all ain't understanding about what's going on. So let's go back here real quick, and I want to show you about this stuff. Trusts are often complex legal arrangements involving state law, a tribal law. They tell you what it's about. Tribal law. They ain't talking about just no damn Indian tribes, because they would have said it here. This is what the Social Security. I didn't make this up. Y'all need to go through, and this is a critical thinking exercise, family. Y'all still dealing with these take it or leave it contracts. Let me see if I pulled it up. Let me see if I got it here. I already talked about original. Let me go here. Let me see. Did I put it on the other one? Let's go. Y'all still dealing in take it or leave it contracts. Here you go. These are adhesion contracts. Take it or leave it contracts, also called a contract of adhesion. It means that the agreement cannot be negotiated. The party being offered the agreement either accepts or denies the agreement, but cannot make a counter offer. Ways to approach a take it or leave it contract. Let's go here, family. Y'all doing the same thing. Listen to everybody and they mama who ain't litigated. When it comes across to a take it or leave it in a type of contract, there are a few ways to handle it in order to still get what you want out of the negotiating. A bid with exceptions. Providing suggestions for alternative contract language. Trigger language. Dun, 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 dun. Red alert. Y'all don't know how to do this. Fairness appeal. Risk control appeal. Incorporation of a proposal. Let's go to a memorandum of understanding. Memorandum. It's memorandum. I'm sorry. Let's go with the template. Memorandum of understanding. Most of y'all don't got y'all forms. Y'all don't got memorandum of understanding. Memorandum of understanding herein refers to a memorandum to enter onto between the two parties and blah blah blah. Right. Whereas the foregoing parties desire to enter into a herein described agreement in which they shall work together to accomplish the goal and objective set forth. Do y'all understand? Man, y'all don't know nothing about these contracts. Memorandum of understanding. Let's go, family. I ain't even go there about all this stuff. Let me see. Let me pull this. So y'all still in these take it or leave it contracts, these adhesion contracts, and y'all don't know what to do. Okay, so here you go. What is an adhesion contract? I ain't gonna go through all of that. A car purchasing and leasing, property leasing, mortgage lending, insurance coverage, home repairs or improvement services, auto repairing, medical, dental, and veterinary services. These are take it or leave it contracts. If a company is in good shape with a solid client base or steady business, they probably have the option to use an adhesion contract. Offering a little room for negotiation to the consumer is a good idea in some instances. However, I ain't gonna go through all of that, right? These adhesion or take it or leave it contracts, I've been through this before, family. So what you got to understand is how to negotiate. They're hitting you with these take it or leave it contracts, these adhesion contracts, and you are falling on your own sword. So I'm just trying to give you some understanding when dealing with contract law. How do you need to be thinking when we talking about this as it relates to the Social security number or any things when we dealing with original jurisdiction. Sui juris matters as it relates to rights to contracts and how the states can't interfere with the contract and how you can enforce your contract and using these agreements and knowing how to write a contract. This is your boy King L. Bay, dropping knowledge all day. This is the part 3. I'm gonna end it here. I'm trying to make these videos real short. So peace and love to everybody. I'm out.